So why this presentation, and how did I manage to convince my boss to send me here instead of someone else from EMA legal department to present something more passionate or interesting? The reason is that on the 5th of February, the General Court finally delivered rulings on access to documents cases on the merits instead of just rulings on the interim orders on request that the agency received for documents we hold and for which we decided to give access, and we were challenged in court. The good news for us is that the General Court upheld all our decisions and dismissed the actions. And most importantly, I think positive for everyone, the court provided answers to very important questions and gave clarity that was lacking so far, both in law and the case law. It's the first time the General Court has assessed of the way we implement the policy, the Regulation 1049. This means our policy, our output table, most importantly, our definition of commercially confidential information. The court accepted our arguments why we think this document should be released and implicitly endorsed our policy, output table, and our definition, which were the critical point of clarity, because justifiably some companies and some individuals were actually questioning who are we to define what is commercially confidential information, who are we to define how the policy is applied, and why do we think we got it right. Well, so far it seems we got something right. Obviously the saga may not be over, or these rulings may potentially theoretically be appealed to the Court of Justice. So what are the cases? The first one is Parifarma versus EMA. We received a request from, now it's not secret, from Novartis to release the superiority and similarity reports, CHMP reports for Vantobra, which is a product for which derogation to orphan exclusivity given to Toby Bothaler was granted. Obviously, Novartis were not entirely happy. We wanted to release documents. We considered there is nothing confidential, save for a few things. The company disagreed. They said everything from start to end is confidential. The oral hearing took place on St. Valentine's Day. So for some of us was very, there was, let's say, some disbelief in the significant others that the court actually asked us to plead on this day. But actually, the court hearing took place on St. Valentine's, and the ruling came almost a year afterwards. The other case, which also Brian represented the client, is PTC versus EMA. The request was for a clinical study report supporting the marketing authorization of the product Translarna. It's an orphan medicinal product. Again, it was actually, two clinical study reports. We considered these are releasable. The company felt that all of the reports entirely are confidential, so should not be released. Again, oral hearing took place in July. And the final, third case is Msd Animal Health versus EMA. Here the requester was asking for 2 toxicology studies with Bravecto, a very popular veterinary medicinal products for dogs and cats, if I'm not mistaken. Again, the company said everything is confidential, and for us in court, we didn't feel that everything in these documents is confidential. And hearing took place in May. Since July, we were waiting, us, the opposing counsels, the companies, and everyone basically to see what the court will say. So what did the court say? My presentation is structured. First, I would present the common points in all 3 rulings, and just then a few things that are specific to each ruling because the documents are not exactly the same and there are some specific questions. So is there a general presumption of confidentiality? This was the main claim made by all parties. It came partially, at least in my personal opinion, from an order of the President of the General Court, who said in the interim order in the Parifarma case that the existence of such presumption cannot be excluded. So this had, for me personally, again, this is my opinion, had a snowball effect. People started claiming that there is actually a presumption of confidentiality. The second chamber of court, the General Court, said there is no such presumption of confidentiality of the documents held by EMA. And there is no system of restricted access to documents that we hold. The fact that we proactively publish e-parse and other documents doesn't mean this is the only publication we can do. This is the minimum we can do, and under 1049 we can release everything that is not protected by any of the exceptions of the regulation. So basically, whatever is in a dossier for a marketing authorization is potentially releasable unless protected by one of the exceptions of Regulation 1049. The TRIPS agreement, a common claim by the companies that releasing the documents, any parts of them, would infringe Article 32, 39.2 and 3 of the TRIPS agreement. The court held that these articles cannot mean that protection granted to IPR, intellectual property rights, must be given absolute precedence over the principle of disclosure of information submitted to EMA. Such position must be rejected according to the General Court because it challenges the legality of EU legislation. EU legislation meaning the Transparency Regulation, our founding regulation, the Orphan Regulation. And the court held that actually the TRIPS agreement is effectively implemented in the EU legal order through the data protection mechanisms and also the Trade Secrets Directive. So there is no problem with us releasing documents in light of the TRIPS agreement. Protection of commercially confidential information. This is not really new. The court repeatedly in all access to documents cases says that the exceptions in Article 4 are of a strict interpretation and narrow interpretation. So if a company or if EMA claims that a document or element thereof should not be released based on the protection of commercial confidentiality, this proof should be brought that the release would seriously undermine the commercial interests of the legal person, and the court gives examples. For example, these are business strategies, commercial relations, information revealing company expertise. What the agency also agrees is commercially confidential is, of course, quality, detailed quality and manufacturing data, usually what we have in Module 3. These are most likely not going to be disclosed by the EMA, at least as it stands now. Future development plans, we fully agree these are commercially confidential. These would never be released. For example, scientific advice documents for products that are not yet authorized or indications that are not yet authorized. We do receive requests for these. We don't release. We don't even consult the companies. We inform the requester that these contain detailed development plans and business strategy. We just don't release them. And the court said that companies, if they want to challenge us, they need to come with specific justifications. Vague and generic explanations are not enough. You can see on the presentation there the paragraphs of the rulings. I did it mostly for my own protection, that it's not claimed by anyone that I'm reinventing what the court said. You can double check that the court actually said those things. And in Paripharma especially, the company was claiming that while approximately 80% of the content of the documents they wanted to protect was in the public domain, and actually was data generated by the FDA and Novartis. Company had nothing to do with generating this data. They just took them and repackaged them, and they claimed that what they did was so innovative and creative that it turned it into something super secret, and we were not allowed to release it. So the court said a claim that the entire document is commercially confidential, must be supported by demonstration that assembly of the publicly accessible data together with the data which is not publicly accessible constitutes a commercially sensitive item of data whose disclosure would undermine the commercial interests of the company. So the company needs to prove why what they did was so creative that it merits protection. Overriding public interest. In all cases, it was claimed that we were supposed to balance the interest in the release against the interest of the companies to protect the data. And it was claimed that we needed to demonstrate overriding public interest in the release. We disagreed with this because for us, we release not the public interest is basically enshrined in the treaty, Article 15, and Regulation 1049, and we check if there is overriding public interest only if we feel, or if we conclude that the document is commercially confidential, but however we want to release it because there is overriding public interest. Our opponents were claiming that this is not correct, and we should every time prove, before we decide to release, that there is a public interest in releasing, no matter whether the document is confidential or not. The court concluded that if we don't conclude that anything is protected by the exceptions, we are not required to assess or demonstrate the public interest. This interest is presumed by the mere existence of Regulation 1049 and Article 15 of the treaty. Another interesting element was the companies were claiming that if we release the data, this data can be used outside the EU by competitors to obtain marketing authorizations without actually conducting any research and basically piggybanking on the research the company did. The court concluded that the non-disclosure of documents in order to prevent the authorities of a third country to get access to the market in a third country without actually submitting a data would amount to depriving the public of the rights granted by EU law to have access to documents containing information relating to the authorized medicinal products in the EU. So the General Court did not agree with this argument about the use outside the EU. So these were the common elements. Since I will just quickly present some specific elements of the cases, which pretty much depend on the factual background. In Pharma, where the company basically compiled publicly available data, the court said that the mere fact that the published data were compiled together cannot in itself demonstrate that it's commercially confidential or that they reveal any strategic know-how of the company. The fact that the applicant performed a search of public information and compiled it is not sufficient either. And finally, the fact that something is not in an EPAR doesn't mean it's confidential, because the purpose of the EPAR is not to outline all the information about the product, it's just to outline why CHMP concluded in a certain way. So therefore, even if something is not in the EPAR that we publish, doesn't mean it's confidential, it just was not relevant to be included in the EPAR as deemed by the CHMP. TRIPS agreement, again, information that is available in the public domain cannot be considered non-registered know-how based on proprietary technical and business information. Basically, the company was claiming that what they compiled was their know-how, even though they compiled data by third parties. The second bullet point, the head of legal, Stefano Marino, who is an expert in trade law, really loved. Basically, the court confirmed that we apply EU law in line with the concept of trade secrets and the TRIPS agreement. Although the Trade Secrets Directive does not apply to the EMA, as Article 2AC, I think, clearly states that the Trade Secrets Directive cannot basically undermine the application of the transparency laws. Basically, institutions cannot infringe trade secrets if they release documents in accordance with Regulation 1049. However, we claim that our concept of commercially confidential information, as set out in our policy, takes into account of trade secrets. We have no willingness whatsoever to disclose anyone's trade secrets. It's just that if we don't think it's commercially confidential, for CORE, we don't consider this to be a trade secret. The company was claiming that the release undermines data exclusivity. We emphasize to the court that because the fact something is published doesn't mean it's not protected by data exclusivity. It's in the notice to applicants of the Commission, which clearly says that anything obtained through access to documents cannot be used in submissions to competent authorities to undermine data exclusivity. And the proof is that many companies publish articles regarding clinical studies that are still covered by data exclusivity. So the company was trying to create a confusion between secrecy and data exclusivity, which we successfully managed to dispel. And in this particular case, in Pharma, the court held that there is an overriding public interest, although they just made it in an additional point, although there was no question about overriding public interest to justify our release. The court considered that there could be overriding public interest justifying the disclosure of scientific evidence when this evidence supports derogations of orphan market exclusivity. The reason is that orphan exclusivity is given to company to incentivize orphan research. So if you make a derogation from this, means that you take away part of this incentive for companies to develop orphan products. then the public needs to know what were the so important reasons that allow a competent authority, in this case the European Medicines Agency, to conclude that the derogation should be made from the orphan exclusivity. Specific learnings from the PTC case. What we use the clinical trials directive, basically saying that the EU legislator, it's impossible for the EU legislator to have considered the existence of general presumption of confidentiality if in the same time they adopted the clinical trial regulation, which clearly states that clinical study reports should be made available once the marketing authorization is granted. And the court acknowledged that the clinical trials regulation do not apply in this case, because the release of the documents is based on Regulation 1049, but it shows the intention of the EU legislators against the existence of a presumption of confidentiality. Confidentiality of the entire documents, again, in all cases, elements of the documents were publicly available, including scientific articles, our EPARs, clinicaltrials.gov. So the court said that the assertion that the whole is more than the sum of its parts is too vague to show that the assembly of information could produce the consequences alleged, this meaning undermining economic interest. This means that the companies need to show why the compilation of publicly available information is such a special exercise that although the information is public, the way it's compiled, it's so special that merits protection under commercial confidentiality. Another point was the potential of misuse. A misuse was meant, for example, for misleading advertising or submitting in other jurisdictions. The court said this potential misuse in itself is not enough to trigger the application of Article 4.2. Decision-making process. In this case, it was claimed that the disclosure of the documents would undermine the decision-making process of the agency because the product was subject to conditional marketing authorization, which was renewed every year. We said no, not really. The court basically agreed with us and disagreed with an argument that the conditional marketing authorization is not the real marketing authorization, is not the final. We said no, it is a final, it just reassessed every year. So the court considered that each renewal is a separate decision-making process, and documents that were concerned by the initial process, their disclosure cannot undermine our own decision-making process. This is one point we were actually unsuccessful in court. We basically claimed that a company cannot invoke the exception of decision-making process because it's for us to protect ourselves. So it's only an exception we can invoke because Article 4.4 says that we consult companies only on the exceptions in Article 4.1 and 4.2. The court said no. You have a legal obligation to consult them on 4.1 and 4.2, but they can come proactively and say don't release the document because it may undermine your decision-making process. So on this one we were unsuccessful. Obviously I didn't put it in the slides, but I'm saying it at least verbally. And finally the MSD case. Again, the court said that data protection, as meant in Article 39.3 of the TRIPS agreement, is protected in EU law, both by the data exclusivity in our founding regulation and Article 4 of Regulation 1049. And such measures are consistent with what is required by Article 39.3 of TRIPS. The possibility that data can be reused does not in itself constitute a ground to grant the protection under Article 4.2. Again, additional arguments would be needed. Or, in this case, Article 4.3 decision-making process. Financial value. One of the arguments we most often see is, don't release this document, we invented a lot of money in generating the document. The court said the fact that the company invests a lot of money in the document doesn't make it necessarily commercially confidential. We need more arguments saying why disclosure would seriously undermine the commercial interests. Because the same thing is generating clinical study report requires a lot of investment. This is, I think, the single most important, clinical research is the single most important, most expensive element, and yet these clinical study reports will be published under the clinical trials regulation, under the EMA policy 70. So the court saw no link between the investment and the commercial confidentiality. I think this is the summary of this slide. You can read in more detail. Reputational damage. Here, basically, the concern of the company was that if we release those documents, competitors are likely to start misleading comparative advertising campaigns to undermine the interests of the company. Our counter-argument was we have the Comparative and Misleading Advertising Directive. It's enforced in all member states. For example, in the UK, you also have industry-regulated monitoring, self-regulation. So this is not an argument for us not to release, because you still have legal remedies to attack a company for misleading advertising. And they can anyway do misleading advertising on the basis of the EPAR or the other documents that are published. The court agreed with us, and they said that this is not a criterion capable of identifying whether or not an item is confidential, just because this can help or facilitate misleading advertising or harming reputation of the company. Again, overriding public interest, the court confirmed that we're not required or allowed to check whether there is overriding public interest when considering if something is commercially confidential. It is only if we say, okay, it's commercially confidential, but we want to release it anyway. This is where we need to demonstrate that there is overriding public interest, justifying overriding the commercial confidentiality. And the final pending case, I'm actually going to plead it next week on the 10th of March in court. It's amicus. Someone requested clinical study reports regarding their product Galafold. Basically, company, all their arguments were, we want to be treated as you treated PTC. So now they need to explain to the court why the court needs to get a different conclusion in this case from PTC, where all their claims are based on parallels between their case and PTC. I don't know how this will go. I don't know when we can expect the ruling. And these are all the cases we have. And I'll hand it over to Brian